Is your local business or organization looking to give back to the community? Help keep our roads clean by joining the Adopt a Road program administered by Keep Tampa Bay Beautiful. Keeping our roads clean is a great way for team building as well as exposure for your business. Select the road your business wants to adopt and dispatch a team to remove litter and debris. Participants will receive 2 signs showing their organization's name as well as safety equipment and instructions for cleaning roads. You can help keep Tampa Bay beautiful by adopting your own road today. To learn more, visit hcfl.gov/cleanhc.
These are the jobs you may not see every day, but just know we're working hard to make Hillsborough County a better place to live, work, and play. Subscribe to our YouTube page for more great county-related videos, only on HTV.
So you have now completed your emergency plan for your family. How about a plan for this family member? Protect your pets during a disaster by including them in your family's emergency plan. Start by making your pet a disaster kit. Put all paperwork into a large Ziploc bag, including a picture of you and your pet, your contact information, vaccination information, and special care instructions. In addition, you should pack certain items to help your pet during the emergency. A 7-day supply of food with bowls, a travel crate, and your pet's favorite toy. Remember, shelters are the place of last resort. Your plan should include being far away from the disaster's epicenter. But if you do find yourself at the shelter, know the rules. Once at the shelter, your pet will be placed in a designated animal section. This is for your pet's safety, as well as other shelter residents. Knowing the shelter rules helps everyone stay safe during an emergency. For more information about shelters, their location, rules, and how to get ready for a disaster, go to hcfl.gov/staysafe.
please stand for the Pledge of Allegiance? I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Thank you. Please be seated. Good morning, everyone. I want to welcome you to the December 17th, 2024 Land Use Hearing Officer hearing. My name is Susan Finch, and I'll be presiding as the hearing officer over today's cases. Let me start by introducing Ms. Colleen Marshall. She is with the Development Services Department, and she will introduce other staff members as well as go over any changes we have to today's agenda. Ms. Marshall.
Good morning, Colleen Marshall, Development Services. To my left is Mary Dorman of the Hillsborough County County Attorney's Office. Carmen Mason, Development Services staff, is joining us virtually today, and Alexis Myers of Planning Commission staff will be presenting virtually as well. During the course of the hearing, a number of other planners will be presenting their findings for various cases and will be introduced for each item. We have a few continuances and withdrawals today. Item A1, variance 241128. The applicant is Rolando Santiago. This application is out of order to be heard and continued to the January 21st, 2025 Land Use Hearing Officer hearing. Item A2, special use 241238. The applicant is Todd Pressman. This application is being continued by the applicant to the January 21st, 2025 Land Use Hearing Officer hearing. Item A3, special use 241335. The applicant is David Wright, TSP Companies Incorporated. This application is out of order to be heard and is being continued to the January 21st, 2025 Land Use Hearing Officer hearing. Now, item A4, variance 250094. The applicant is Global Sign and Awning. This application is out of order to be heard and is being continued to the January 21st, 2025 Land Use Hearing Officer hearing. This concludes the continuances today.
Thank you so much. I appreciate it. We'll start by going over our procedures for today's hearing. Our hearing today consists of agenda items that require a public hearing by a land use hearing officer. I'll conduct a hearing on each agenda item and will file a decision within 15 business days following today's hearing. Our hearing today is informal. I'll ask questions related to the scope of direct testimony. I may call and question witnesses as I deem appropriate and will decide all questions of procedure. I'll take evidence, but will exclude evidence that is irrelevant, immaterial, or unduly repetitious. Evidence may be presented in written form, and all testimony must be under oath. Hearsay evidence may be used to supplement or explain other evidence, but shall not be sufficient alone to support a finding by me unless it would be admissible over objections in a civil action. Our order of presentation today is as follows. You might have noticed we have a very, very short agenda today. We have one variance and two special uses, and that is it. So the order of presentation, the Development Services Department presents the staff report and finding for variances. They go first for a period of 5 minutes. Then next is the applicant. The applicant has 15 minutes to present their findings. Next, we'll go to proponents. Anyone who would like to speak in favor of an application has 15 minutes total for everyone, and the same is true next when we go to opponents, everyone combined 15 minutes. We'll then go back to Development Services, who has 5 minutes to make any comments or changes based on today's testimony, and then finally, the applicant has the last word with rebuttal for 5 minutes. The only difference is in the variances, the Development Services staff goes first. For special uses, the applicant goes first. That's the only change. All right, I don't think we'll have this issue, but if there are people that would like to speak either in favor or against, I'll ask for a show of hands. We have people participating in the room and also virtually today, and I'll count those hands of people that would like to speak either in favor or against, and we'll divide that 15 minutes as equally as we can. If you are in the room or online when you begin to speak, if you could please give us your name and address for the record. We are recording this hearing, and we want to make sure that we have everyone's information correct. If you're in the room and you're done with your presentation or comments, if you could please see Allison. She's at the end of the dais. She's with the clerk's office. She is keeping a log. And so when you're done, if you could see her to sign in with your name, address, and the case number to which you spoke. Let me now turn to Ms. Dorman with the County Attorney's Office, who will provide you the legal requirements for appealing a decision made by a land use hearing officer. Ms. Dorman.
I'm Mary Dorman from the County Attorney's Office. This land use hearing officer public hearing is for variance and special use requests. This is the time for interested parties to present evidence and testimony. Once the land use hearing officer has closed a case, the record of that case is also closed, and no new evidence regarding that case may be submitted thereafter. Any decision by the land use hearing officer may be appealed to the Land Use Appeals Board. Should a decision of the land use hearing officer be appealed, the record evidence, including the testimony presented at its public hearing, shall be the only evidence that is subject to review by the Land Use Appeals Board. In reaching a final decision on petitions, the Land Use Appeals Board will only consider the decision of the land use hearing officer and record evidence, including any evidence from this public hearing. If an appeal is filed, the Land Use Appeals Board hearing shall consist of oral argument by the party appealing the decision, county staff, and any interveners, each of whom may be represented by legal counsel. The following shall have standing to appeal a decision of the land use hearing officer or to intervene in an appeal. 1, the applicant, or 2, anyone who appeared before the land use hearing officer, presented testimony or other evidence, and is adversely affected by the decision of the land use hearing officer. It is the role of the county attorney's office to ensure that no new evidence or testimony is allowed before the Land Use Appeals Board that was not presented to the land use hearing officer at today's hearing. The county attorney will recommend that the Land Use Appeals Board disregard evidence or testimony that is outside the record made at today's public hearing. Any evidence presented to the Land Use Appeals Board that is outside the record created at today's hearing could jeopardize the legality of the Land Use Appeals Board decision, and the presenter of that evidence could hurt their own cause. The safest course of action, then, is for you to write down any comments you make today and repeat them to the Land Use Appeals Board.
Thank you, Ms. Dorman. I appreciate it. I neglected to list one important agency that also testifies regarding the second item. We have the special use. The Planning Commission will be testifying virtually today on that single case, and they go after the Development Services staff person regarding that. So just that one change. Now, as I mentioned, all testimony must be under oath. So if you plan to speak today, if you could please stand, raise your right hand, and I'll swear you in. Do you solemnly swear the testimony you're about to provide is the truth, the whole truth, and nothing but the truth? All right, thank you so much. Have a seat, and with that, Ms. Marshall, we're ready for the first case.
Today's agenda, we have no vested rights, fee waivers, remands, or reconsideration requests, or site development variance requests, which brings us to Section G, sign variance request. Item G1, variance 250002. The applicant is Kendall Signs. The request is a variance to sign requirements. Staff findings will be provided by Michelle Montalbano.
Good morning.
Good morning, Michelle Montalbano, Development Services. The applicant is requesting a variance to sign setback standards for a proposed monument sign. The site is a new freestanding emergency room in the Kerrwood area along Northdale Mabry Highway. The request is for a 10-foot setback to the front property line for a 15-foot tall monument sign. Per LDC Section 70300C1C, monument signs require a minimum 15-foot setback and then an additional foot of setback for every foot in height the sign is above 4 feet in height. Therefore, the 15-foot tall monument sign would otherwise require a 26-foot setback to the front property line, resulting in a 16-foot variance request. The subject monument sign has an approved building permit placing the sign 55 feet from the front property line along Northdale Mabry Highway, which the applicant would like to revise to 10 feet. I'm available if you have any questions.
No questions at this time, but thank you so much. Is the applicant here? Good morning. If you could please come forward and start by giving us your name and address. Thank you.
Good morning. My name is Angela Kopnicki. I live at 1680 Promenade Circle, Port Orange, Florida.
All right. If you could just tell us a little bit about the variance request.
Okay, so this is for Advent Health. It's a new off-site emergency department. And currently where we are approved for the monument sign, it sits 26 feet back from the property line. And if a patient were in dire need of emergency service, there's only one entrance off of Northdale Mayberry for them to get into it. So they would literally have to go all the way down, make a U-turn, make another U-turn to come back to get the service. So we're just trying to see if we can move the sign up closer just for emergency access and would not obstruct any traffic or anything like that. Because if the sign didn't have, I have a picture of the sign, I'm not sure if you guys are. So,
You can put it on that overhead right next to you, and that microphone pulls towards you so you can still stay on the record.
sorry. So as you can see, because the sign, you cannot see the pole, they have cladding going all the way down, is considered as a monument sign and not a pylon sign. If we were able to just to show the pole, then we would be allowed the 10-foot setback, but because the cladding goes all the way down, we have to do 26 feet setback.
I see.
I actually have the site plan, if you guys want to see that as well. It's real big, I'm not sure it's going to go on there.
That's something you previously submitted into
Yes.
the record, then I have it.
Okay,
But I
perfect.
appreciate that.
All right, no worries.
Does that complete your presentation?
That would put, yes.
All right, thank you. I don't have any more questions. If you could
All right.
please sign in with the clerk's office.
Absolutely.
Thank you so much. Is there anyone in the room or online that would like to speak in support? Anyone in favor? Seeing no one, anyone in opposition to this request? No. Development Services, anything else?
Nothing further.
Okay, ma'am, you have the last word if you'd like it, but you don't have to take it. Okay, thank you, I appreciate it. Then with that, we'll close variance 25-0002 and go to the next case.
We have no Section H variance request, which brings us to Section I, special uses. Item I-1, special use 240625. The applicant is Harvest Time of Tampa Incorporated. The request is a special use for a church, child care center, and school, and variance to lot development standards. Sam Ball will provide staff findings after presentation by the applicant. Alexis Myers will be presenting Planning Commission findings virtually.
Okay, thank you so much. Is the applicant here? Good morning.
Good morning. My name is Colin Rice at the law firm of Older Lundy, 1000 West Cass Street, here on behalf of Harvest Time, Inc., and I have been sworn. So give me one moment, I'll prepare a set of visuals for you.
Okay.
You see that?
I can.
Okay. Excuse me. All right, good morning again. Colin Rice here on behalf of the applicant. I am joined this morning by Margaret Tassone with the firm of Landis Evans, should there be any technical questions about the site plan or anything with that respect. Harvest Time Church acquired the subject property in 1971. And since 1978, they've been continuously operating as a church, child care center, and school. Today, we're seeking to formalize these uses. No changes in use are proposed, no new structures are proposed, and no increase in intensity is proposed. These community anchors are looking for a declaration of rights. The special use process is the appropriate vehicle for that. This application has a robust record. Our office submitted a memorandum last week with supporting documents, which I'll reference this morning, and I do have paper copies for everybody today as well. As you consider this request and all the evidence submitted, I want you to keep three core concepts in mind. One, this is a weird site with weird access. It's crucial to remember that the neighborhood grew up around Harvest Time, and the access today is the direct result of a government taking when US Highway 301 was expanded in 1980. Two, the state of Florida owns the large parking area north of our property. As a matter of law, state property is not subject to local zoning regulations. Harvest Time has an agreement for parking on this property. And three, the proposed use is the same as the existing use. There are no new impacts. Therefore, conditions beyond what can be reasonably accommodated would be unlawful government exactions. And so just to highlight for the record, while we have some disagreements with staff, I do want to compliment their professionalism, their responsiveness through this process. For that, we're very thankful. So I'll introduce you to the site as it exists today, and then give you some historical context. So to orient you, this is the aerial from the staff report. Our site is wedged here between the Crosstown Expressway and US Highway 301. In the greater Palm River area, we're within the urban service area. The comp plan future land use designation is CMU 12. All proposed uses are allowable under the comp plan and under the Land Development Code with special use approval. Zooming in, the site's actually chopped up into several zoning districts. There's RSC 6, CN, AR, all of which allow the proposed uses via special use approval. To the north and west is self-storage. To the south is a retention area. To the east is US Highway 301. Oh, I'm sorry. To the north is, I'm sorry, I don't know if you heard that. To the east is US Highway 301. To the north, this is the state-owned parking area. We'll get to that in more detail soon. And you'll notice a gap here. That's an old right-of-way that has been vacated. The site is unified. Showing you now the site plan. There's a primary two-story structure built here in 1990 after a fire to the original facility. And then a modular structure here, which had hosted church services. The remaining features are proposed queuing, on-site parking, outdoor play areas, things associated with this type of use. This is the zoomed-in excerpt from the merged queuing and event planning plan, or event parking plan. Current code requires queuing for school uses. Our engineers, and again, Ms. Tassone with Landis Evans is here to answer questions. They prepared this plan in conjunction with a drop-off pickup area. This represents optimal queuing possible for the site given its constraints. So taking us back in time, and this is in our memorandum along with some other supportive material. This is an article from 1990 giving a little bit of history and context to the site after the fire in 1990 when they rebuilt the structure that exists today. Highlighted here in red shows the facility had opened its doors in 1978 for these uses. This aerial from 1980 shows an operational harvest time site when the parking area and the Crosstown Expressway are being constructed. So Crosstown here, you can see it's dirt being laid out for what is now the Crosstown. This is 301. Importantly, we want to note that there was direct access to 301 in 1980. This 1987 aerial shows the constructed parking lot, the constructed Crosstown Expressway, and the closed access to 301. This is an on-ramp going southbound from 301 to merge onto the Crosstown. Again, the site used to have direct access. So again, the county, the neighborhood is growing up around us. So this is the site today. Harvest Time is cornered in by new development, but continuing to serve this community with not only compatible but sorely needed community supportive uses. As mentioned, FDOT, the state of Florida, owns this parking area. They are a state agency. Hillsborough County is a political subdivision of the state. We've had numerous meetings with the county, with FDOT. The agreement in place will remain as is. To that end, as a matter of law, and we have an attorney general opinion in the record to support this, Hillsborough County cannot compel the state to amend an agreement entered into with a third party. And again, that's attorney general opinion 75-207, which is in the record. I'll submit a paper copy as well.
Can I stop you
Sure.
at just that one point? I apologize for interrupting, but I don't want to leave that point. So what agreement is in place currently?
There is a 1987 parking agreement between FDOT and the church. It's in the record, but it provides for parking associated with the uses on site.
And it identifies their property
Yes.
as the landowner and
Correct.
the church as, and does it also include the school and the child care center?
So the agreement, and I can pull it if you'd like, it's a little tedious, but I can find that for you. The agreement is between the state and Harvest Time Church, which is a named entity, and I think that there's a bit of confusion about church referencing church use, but church, child care center, and school had been in operation for 9 years prior to the entry of that agreement. So, agreements that run with the land are a snapshot in time. the uses we're proposing today were in place at the time that that agreement was entered.
Okay, thank you so much.
Sure.
Please continue.
Okay. And that was my next point. I just answered it. Okay.
Oh.
So thinking the same way. Again, important to note that the use and the scope are not increasing. When the church and school burned down in 1990, they rebuilt, they had building plans, and right now it's rebuilt in largely that configuration with some amenities for the child care uses. So to touch again on the notion of prohibited exaction, section 70.451D defines prohibited exaction to mean any condition imposed by a governmental entity on a property owner's proposed use for real property that lacks an essential nexus to a legitimate public purpose, and 2, is not roughly proportionate to the impacts of the proposed use that the government entity seeks to avoid, minimize, or mitigate. And to remind everybody, there are no new impacts. The existing uses are the proposed uses. We went to pretty significant efforts to provide design features, bring queuing and parking on site, to keep operational impacts as efficient as possible. And they're arguably better in this proposal than they have been existing. We have provided proposed conditions of approval, which I'll show in a moment. But it's just a matter of impossibility meeting some of these remaining requirements. So the aforementioned proposed conditions of approval are here. So the on-site parking facilities, we commit to compliance with Land Development Code standards for compact and ADA and otherwise. To the extent that it's on our site, we will do so. Second, site queuing and circulation, to the extent within our control, will adhere to the prevailing safety standards as determined by the administrator. And 3, we recognize that the parking situation is probably not one that we see every day in these types of hearings. It's unique. We understand that this is through private agreement with the state agency, and that operations are dependent on this agreement. So this or substantially similar type of agreement, we understand needs to perpetuate into the future.
Does the agreement, and I'm asking because I haven't seen it yet.
Sure.
Is the agreement have some sort of sunset provision, or is it in perpetuity?
It's ongoing. It can be terminated by operation of notice from the parties. It has been operating seamlessly since 1987.
Okay.
So to conclude, well, a couple of housekeeping items. And again, all of this is in the record. I'll direct you to the memorandum and supporting submittals. We do have 2 variance requests, 60604D. There's a perimeter buffering requirement that we need relief from to accommodate the optimal queuing. Justifications for that are in the record. Section 60101. One of the sections of land is zoned AR, and it has a 25-foot rear setback. The structure is 10 and change feet from that setback. We're asking for relief from that standard. We've also provided responses to the December 3rd transportation comments, and we have an engineer's parking verification letter in the record. Again, Ms. Tassone can speak more specifically to that should there be questions. So we'll bring us back then again to our 3 core concepts. 1, this weird site is the product of a government taking after being fully operational. 2, the state owns this parking area. The state is immune from county regulation. We have an existing agreement for parking. There are over 100 spaces. Again, I'll reference Attorney General Opinion 75-207. Lastly, the proposed use is the same as the existing use. There are no new impacts. Unreasonable conditions constitute unlawful exactions. And we completely appreciate concerns about safety. We're in the same boat. The site is safe. It operates safely. We've pulled crash data from the last year. The connection to 301 is not within the top 100 intersections in the county for crashes. There are no code enforcement issues of record. We've pulled the crime statistics from Hillsborough County Sheriff's Office. There's not a single crime incident in the last 20 years on this site. It operates safely. It will continue to do so. And again, just to frame this again, they've been operating since 1978 with repeated approvals, including from 2019, an updated building plan approval. Again, no school operational issues, and the uses are complementary. There's very rarely overlap in parking needs. So with that, I will conclude. I'm sure I will see you on rebuttal. I appreciate your time and consideration. I'm happy to answer any questions.
I do have some questions.
Okay.
I like to start with how we got here. So how did this all come to light if it's existing and you're asking for no changes? How did this issue come up?
It's a fair question. So there, as you can see, there is some uncertainty about this site. It's just been existing for 46 years and operating. We need a clear declaration of rights. That's important for a number of reasons: marketable title, regulatory agencies elsewhere that aren't, within Hillsborough County. It's important to know what are we dealing with from a reliable perspective going forward.
Okay. And you just mentioned code enforcement, and on an application that I read in the record yesterday, the box was checked yes for you're under code enforcement violation. Is that just an error?
I will have to double check that. I
Okay.
apologize if
All
I had
right,
misspoken.
So that was my second question I was going to ask about the
And I
violation.
told just candidly, last night I searched the code enforcement records. I didn't see any hits.
Okay.
So
This
I'll
was
circle
actually
back on
your
that.
application where it says, are you under code enforcement violation? Yes, no, and the yes box was checked, as I recall.
I'll
So-
take a look at that. I'll
All right,
address that
thank
for rebuttal. I'm sorry.
Okay. Why did not, in trying to establish their rights and document them, why didn't you just go the route of legal nonconforming use? If you can document it back to 78 and so forth. And then further, if there was a fire in the 90s, was a building permit pulled to reconstruct that church?
So first question, we could have, and we feel very confident that it could have been approved for a legal nonconforming use. We had engaged in discussions with folks over at the zoning department, and through discussion and agreement, we collectively determined to go the special use route. We could, we feel confident that we've got more than ample evidence to establish a nonconforming use. The problem isn't the use, it's that the parking and the setbacks, and it's more of the physical orientation. The uses, and you'll notice in the staff report and in the Planning Commission comments, there's not a problem with the use. It's about the weird dimensions.
Yeah, understood. Use is the wrong word
Right.
on my part. Absolutely. All right. And then also, an obvious question is transportation is opposing this due to their assertion that there's a lack of information and data that's been submitted.
Mm-hmm.
And what is your position on that, and why not just address their concerns and give them what they want?
Fair. First, we can't. We don't own the state of Florida property. So we just simply don't have an entitlement to, A, binds them to a local regulation, and B, modify anything existing on the ground. We've had discussions about doing that. It's not possible, and as a matter of law, it can't be compelled by either us or the county. We've done the best we can with this site. And the reason, one of the comments has to do with the lack of submitting a transportation study. We again go back to the key notion that we're not introducing any new impacts. This will continue existing in its previous state. It would have qualified for a nonconforming use, but again, we have dimensional issues. So the nonconformity aside, its operation into the future does not introduce new vehicular impacts. And to that end, and you'll see in the queuing plan, we've marked out specifically there are stations for personnel for drop-off and pickup. We've really embraced and tried to do the most that is possible given these constraints.
Okay. It seems in my reading of the record that both planning staffs certainly support a school and a church and a child care center in this residential zoned area. But it's the transportation that seems to be the sticking issue. And so it's your testimony that you were unable to provide them the information because you don't own where the parking area is.
Well, it's not so much the information, it's that there are no new trips proposed, right? So that's when you're looking at, and typically special uses are introducing a new use. New means this is, we have a static condition here. We're proposing something new, we need to evaluate those new impacts. Here, there are no new impacts. Right, so from a traffic and intensity perspective, there is no change.
Okay. I think that's all I have at the moment. Thank you so
Okay,
much. If
thank you
could
so
please
much.
sign in.
Sure.
Thank you.
Oh, and I will submit copies of our memoranda for the record. I have 5. That seems like a lot. How many do you need?
I think just one.
One.
Yeah, she'll put it in and then she sends it.
Would you like a copy as well?
If you'd like.
Okay.
That's fine.
Thank you.
Not to waste the paper. All right, Development Services. Good morning.
Good morning. Sam Ball of Hillsborough County Development Services. The applicant is requesting special use approval for an existing church with 122 seats in the main congregation area, a private school of grades kindergarten through 8th, with up to 8 classrooms and 65 students, and a child care center with 5,623 square feet to accommodate up to 55 children. The application includes a variance to vehicular use area buffer and setback requirements. The property is zoned RSC6, CNAR, which permit the child care and schools through special use approval. The applicant is requesting a 14.27-foot reduction to DRC section 60101 for a setback variance from the north adjoining boundary of the property, having folio 71990.0000. It's a DOT-owned property, this would result in a 10.73-foot setback where 25 feet is required. The applicant is also requesting a variance to 60604D to reduce the vehicular use area by 5 feet and waive the tree planting requirements, which would result in a 3-foot vehicular use area buffer where 8 feet is required. That's on the parking lot area south of the mini warehouse. The application and development plan show that the school and church could comply with the special use requirements of Part 611 during site plan review, but based on the zoning and development pattern in the area, staff finds the proposed uses compatible with the surrounding area. However, because off-site parking would not be in full compliance with the LDC due to perpetual easement agreements, only 12 of the 68 minimum parking spaces would comply with the LDC. The application indicates that the use has 22 employees, which cannot be accommodated on that for that portion if the current site plan agreement, the current off-site parking agreement is discontinued. Additionally, county transportation staff were unable to fully evaluate the proposed plans for compliance with the DPRM and the LDC. The application does not include or demonstrate a trip generation site analysis. Neither the application or county records show that the site was ever reviewed for transportation impacts or requirements to allow the school and child care uses. The application does not include a letter of no objection from the Department of Transportation. The application does not include all the plan sheets required by transportation, which are a separate site, circulation and queuing, and parking special event plan, an alternative parking plan to allow for 50% of the on-site parking spaces to be designed as compact spaces. The proposed plan does not show compliance with minimum ADA parking standards. Pedestrian access to US 301 is insufficient and may not be permitted due to DOT ownership, and several deficiencies to permit off-site parking remain unresolved. The evidence provided by the applicant supports a finding that the church, school uses existed on the property prior to July 26, 1989, but the county records do not support a finding that the school and child care uses were legally established. Therefore, the childhood and school uses could not be approved as legal nonconforming without more documentation to support it. Based on these considerations, staff is unable to support the application and is recommending denial of the special use application. I just want to add, transportation is also online. James Ratliff, if there's any transportation related questions.
I see that, and I will have a couple of questions for him. I just have a couple for you before you go. The off-site parking requirement in the code 60502D, it says that you can have off-site parking if it's subject to certification by the administrator, and then there's a whole list of requirements that are required to be met. And in your narrative of your staff report under 7.1, it says, however, because the off-site parking would not be in full compliance with the LDC due to perpetual easement requirements. What does that mean?
The part of in the LDC, there are certain requirements that would allow for off-site parking, and I believe the easement has to be recorded from transportation, section of transportation. They said that has to be a perpetual easement, that it would basically have to be permanent.
So that the county, are you saying the county would have to be a party to it?
No, whoever owns the property would have to grant the easement, and it would have to be recorded, and it would basically be non-revocable.
I see. And so is it your position, I don't want to put words in your mouth, but is it your position that this is an agreement between the state and the church and not an actual recorded easement?
Well, the code requires an easement.
And there is not an easement in this case?
Correct.
Not
one
it's
that's
an
recorded.
agreement.
Correct.
Okay. And then secondly, going back to my question that I started with, that code provision, 60502D, that says you can have off-site parking if you meet these half a dozen requirements. So it's the county's position that they do not, because there is no easement, correct?
That's correct.
Okay. And it says the use being served by the off-site parking shall be a permitted use as established in Article 2 in the zoning districts within which the zoning lot containing such parking is located. So what does that mean to you?
So basically, that would mean that, can you repeat that?
Yeah, of course. I'm just reading. The use being served by the off-site parking shall be a permitted principal use as established in Article 2 in the zoning district within which the zoning lot containing such parking is located.
So that would mean that the parking would be allowed. So like, let's say it was a use that did not allow that for off-site parking, then.
So that parcel is zone CN is my recollection, right? I think that's right. Zoning map. Yes.
I believe it is.
So of course, off-site parking would be a permitted use. So it would meet that test.
Correct, but it's still, there's, with the off-site parking, there's several requirements, and
That's
the
what I'm
easement was the
looking at.
main.
And the easement seems to be the critical one that they don't have from the county's perspective.
That's my understanding, but the transportation,
And I'll get to Mr. Ratliff.
they,
I don't mean to put you on the spot.
they're the ones who really process the.
Okay. Back to my question of Mr. Rice, why didn't you go the non-conforming condition, perhaps not use, but you haven't seen enough evidence, or the county hasn't seen enough evidence that they have submitted to perhaps entertain that you could make that a finding. Is that correct?
That's correct, yes.
Okay. All right. I think that's it for now. Thank you so much. I appreciate it. All right, Mr. Ratliff, we've been talking about you, and now it's your turn. So I give you the floor for whatever comments you have, and based on the conversation we've had so far. Good morning.
Good morning. James Ratliff, Transportation Review Section of Development Services. So I think that the non-conforming use issue, I think Sam has addressed that. We've also addressed that in our comments to make it clear why it's not clear to us that those uses were operating or appropriately reviewed. With regard to the FDOT ownership issue, there was a time when the applicant had been proposing queuing on the FDOT property. They modified their plan to change that, and so we were, because of that modification, we're no longer seeking that the FDOT land be included in the special use area. I just want to make that clear. The Land Development Code does provide for off-site parking allowance subject to meeting those performance standards and the requirements for the easement, but with respect to if the applicant isn't using that for a static queue line, that land, then it wouldn't need to be included in the special use area because we don't have those performance standards that we place on all charter schools, the ability to reconfigure the queue line in case there's queuing and circulation issues. So again, that's not an issue. I just want to make clear we're not saying that the applicant needed to include that FDOT property in the special use based on this current iteration of the project. With respect to the parking agreement issue, the the applicant stated that they can't compel the state, or the county can't compel the state or the private party to amend an agreement. I'm not an attorney, that may be true. But again, that also doesn't mean the county has to accept any document that's put before it for the purposes of complying with the Land Development Code and being sufficient to determine that it complies with our standards. And again, that parking section of the code states that the reciprocal easement has to be sufficient to the county attorney's office. I worked with the county attorney's office to come up with essentially what does that look like? What are the elements of the agreement? And that's set forth in my staff report there. Again, some of the issues are that the current agreement has the potential to terminate the agreement. It lacks a guaranteed number of spaces. It even discusses the possibility that the easement may provide no parking whatsoever, because they're only allowed to use spaces that are not in use for park and ride. So that could change. So essentially what we're being asked is to have this easement that can be terminated in the middle of the school year, or have parents show up to a park and ride facility that is completely full because they're not exclusive use spaces. And how can the county approve a use with a fluctuating number of parking that may not even be there or could be terminated in the middle of the school year? And so that's one of the reasons why, again, we've got the framework for what a reciprocal easement that again, we worked with the county attorney's office to determine would satisfy that parking code. There's also things in the staff report that I mentioned about, having to be within a 300-foot walking distance, which is why the exact location of those spaces is critical. And the easement is not specific in terms of, or the agreement is not specific in terms of those features. And again, the lighting issue, which speaks to safety. It's not only about safety on the external roadway, but we're also concerned about safety of students walking in that parking area. And that's one of the reasons the off-site parking code speaks to the ability to determine lighting and things of that nature. So again, those are things that we found had not been addressed. And the last thing I would just say based on what I heard is again, I think the applicant sort of was implying that a lot of these things are exactions. And again, in my opinion, constituting with performance standards in the Land Development Code is not an exaction. These are things that are necessary to demonstrate the continued availability of parking and the safety of parking and the ability to access the school site. So with that, I'm happy to answer any additional questions you have.
I think you have answered my questions very thoroughly, and you're referencing that same section in the code that says for off-site parking has to have an appropriate reciprocal easement satisfactory to the county attorney's office and recorded with the clerk. So I understand that. So I don't think I have any more questions at this time for you. I appreciate your testimony. Let me just, before we move on to the Planning Commission, let me ask Ms. Dorman if you are familiar with this agreement, the parking agreement.
I am not, Madam Hearing Officer.
Okay, so you weren't, Mr. Ratliff referenced he worked with the county attorney's office, but not specifically with you.
It was not with me. It may have been with one of my colleagues.
I see. Okay, all right, thank you so much. Then with that, we'll go to the Planning Commission, who's participating virtually.
Yes, good morning, Alexis Myers, Planning Commission staff. The subject property is located in the residential 4 future land use category. The site is in the urban service area and within the limits of the Seffner Mango Community Plan. Overall, staff finds that the proposed use is an allowable use in the Res 4 category, is compatible with the existing development pattern found in the surrounding area, and does support the vision of the Seffner Mango Community Plan. However, due to the objections from transportation, the proposed special use will allow for development that is inconsistent with the goals, objectives, and policies of the future land use element. Based upon those objections from transportation, Planning Commission staff find that proposed special use inconsistent with the unincorporated Hillsborough County Comprehensive Plan, subject to the proposed conditions by the Development Services Department.
Thank you so much. I appreciate it. We'll ask for anyone that would like to speak in support. Anyone in favor? Seeing no one. Anyone in opposition? All right, no one. Ms. Marshall, do you have anything else you'd like to add?
Just want to clarify in regards to the non-conforming use certification. It's a little bit different than non-conforming lot, where it's a non-conforming lot is anything prior to July 26, 1989. For non-conforming use, it requires that that the use established is legally permissible at the time of development. So it goes back to, exactly when it was developed. even if that was further in the past. It can give you a little more background on the zoning if you would like.
Yeah, and I think, are we more specifically talking about a characteristic of the use, the parking, the access, the queuing, and so forth? Because is it true that the actual land use of the property is permitted?
The land use, the
use of the property, not the land use.
So the church is a permitted use for any of those zoning districts that it resides in. The childcare and the school are require a special use.
I see. Okay.
For approval.
Okay. Yeah. If you'd like to give me any more information on the background, that would be terrific.
Sure. So prior to submittal of the special use application, we had looked at the previous zonings and looked for any prior approvals. We did find, some documentation of the church, but we had not found anything in county records specifically to the school and childcare. Looking back to the zoning from the late 1970s into the 80s was R1MH and A. And the R1MH allowed churches and schools and allowed the child care as subject to special use approval. So the child care would have still had to have that special use approval, would have to have some documentation of that. And then the A district did allow the churches, schools, and child cares. So essentially staff wasn't able to find enough documentation to support a non-conforming use.
And
approval.
So then it was decided that they would go the special use route.
Correct. The initial application that was received was a zoning verification letter, and they were looking to confirm that all three uses were legally permitted, and that was where the sticking point was.
That's the source of my question, because it seems there's a much easier path to this, but if you can't provide documentation, then of course there's other routes.
Right.
Understood. All right. Then with that, we'll go back to the applicant, who has 5 minutes for rebuttal.
Okay, Colin Rice again for the applicant. Thank you everybody for their thorough comments and input. I'll address a couple of quick points and then get into a little bit more substance. One comment with respect to the plan sheets, the queuing and event planning are merged onto one document. All the same information is there. I'll remind everybody that the 301 access, the lack of it today is due to a government taking. 301 was expanded to allow for the on-ramp onto the crosstown. It was not our choice, it was not Harvest Time's choice to be in this predicament, it was a government action. With respect to the off-site parking, I do want to show a section from 60502 of Land Development Code B, which talks about off-site parking spaces should be within 300 feet of the entrance or land area. That is the case. It is within the land area, 300 feet. So that's 60502DB. We'll again show our conditions of approval, proposed conditions of approval in concert with the proposed site plan, queuing plan, and event parking plan. We're committed to on-site spaces being LDC compliant. This has operated safely. The record is now closed. I have the final word. There is not a single shred of evidence in the record that there's been an incident or issue with respect to safety for 46 years. We did conduct an additional search for code enforcement activity, received no results. So, I apologize if that box was checked on submittal. We're not seeing any record of code enforcement activity. If there's something out there, I'm just flagging, we don't see anything right now. And then, we get it. We are taking on the burden of this private agreement with the state. And with respect to county requirements governing off-site parking agreements, they're just preempted, period. I have and this again is in the record just submitted. This is Attorney General Opinion 75207. I'm sorry that we can't see all this, but I'll go to the end. You've got a lot of Christmas reading, I'm sorry, but this is, again, in the record. But to conclude, the state is immune from local regulation unless the legislature provides otherwise. So there's no way to impose an off-site parking set of Hillsborough County regulations onto state land. It's just preempted. I do want to mention as well in our initial submittal narrative, cites specifically to architectural plans submitted at the rebuild of the church. On those plans includes educational use. So zooming out a little bit, Harvest Time planted their flag here. Purchased in 1971, opened their doors, serving their community since 1978. The neighborhood and the regulatory world around them evolved pretty significantly over the last 46 years. I really have to stress the no new impacts, the no incidents of any problems, any safety. We're committed to this being a safe site. And given the, again, weirdness with the access, the state agreement, and the product of our being wedged into these two government-controlled thoroughfares is not the result of actions of the applicant. This all happened around us. But going forward into 2024, nearly 2025, and into the future, we need a durable set of understandings about what are our rights. This is the path. We feel good about this. I would again turn you back to the record should you have questions. I assure you they are likely answered in our submittals. With that, I will close. Really appreciate your time here on a Tuesday morning. Happy to answer additional questions should you have any.
I do.
Okay.
What is your position on the state parking agreement, and it not, and to Mr. Ratliff's point, maybe it's an overarching, you don't think it applies at all, that it doesn't identify used space, because that area is still used as a park and ride, separate and apart from Harvest Time. Is that correct?
Yes.
So there's an inherent unpredictability of maybe that could be full and not usable for Harvest Time's purposes, and therefore creating a safety concern and so forth. What is your position on that?
Completely fair question. I'll go back to the record. Right, these decisions have to be based on competent, substantial evidence in the record. And to that end, I'd like to submit our findings with the Hillsborough County Sheriff's Office. There have been no crime incidents for 20 years. There's no record evidence of safety, a capacity, a compliance, a congestion issue at all. So absent evidence to that point, we're left with, after an open records period, understanding there have been no safety or operational issues for 46 years to the extent that we're aware. So we understand and we appreciate that the county is concerned about safety and operational flow and optimization. There's just no evidence that there's a problem.
Okay. I don't think I had anything else, unless you wanted to have the last word.
I will conclude. I will submit the sheriff's records with respect to crime activity for the last 20 years. But with that, I'll close.
And the agreement obviously is in the record.
It's in the record several times. Okay. You'll be able to find it. Thank you so much.
Thank you for your time. Everybody's signed in, I believe. Yes. Then with that, we'll close special use 24-0625 and go to the last case.
Last item is item 8I2, special use 240040. The applicant is Josephine's Italian Market, LLC. The request is a special use 2 COP alcoholic beverage permit with separation waivers. I will present the staff findings after presentation by the applicant.
Okay. Is the applicant here?
Yes, ma'am.
Good morning.
Good morning. How are you?
Good, thank you.
Yes, this is for Josephine's Italian Market at 730 West Brandon Boulevard. He is requesting a 2 COP beer and wine on and off premises.
Miss Liberty, could I stop you? I apologize. One is I need your name and address, and two, your camera has to be on.
I don't know what happened to it. It went off.
All right.
Dixie, go ahead and click that start video button again for me.
It's not there, sweetie.
It's not down at the bottom of the WebEx.
Nope. All I got is a little blue dot, and I'm pushing it, and there's nothing there.
We can try having you log out and log back in and see if that resets the system.
You're unmuted. I don't know why it won't do it. Do you want me to leave the meeting?
Madam Chair, do you mind if we resolve this issue really quickly?
Yeah, because otherwise she can't testify. We need her.
Okay, absolutely.
We need
Yeah,
her
so
face.
Dixie, go ahead and log out and then log back in.
All right,
And
I'll
then if
come
you
back.
need to, you can talk to me on your phone.
I'll tell you what, why don't we take a 5-minute break, and we'll come back at 10 o'clock and hope that Miss Liberty is seen to us. So we'll come back at 10 o'clock.
You there?
All right, welcome back to the December 17th, 2024 Land Use Hearing Officer Hearing. We have Ms. Liberty, I understand, so let's continue. Ms. Liberty, if you give us your name and address, and I see your face, so good job.
Dixie Liberty at 200 Adams Avenue, Hopkinsville, Kentucky, 42240. My client is Josephine's Italian Market at 730 West Brandon Boulevard. He's requesting a 2 COP beer and wine on and off premises. The building can 2382 square feet. There is no outdoor seating. This is going to be a quaint little restaurant where you can go in and eat, or you can take it to go. Requesting a waiver due to Russellwood condos. They are at 230 feet away, requesting 8 feet. The residential, to reach the residential property entrance, travel east on Highway 60 to the entrance. The business spaces to the south. And behind there is a 6-foot concrete wall and a drive that separates the building from the condos.
Okay, does that complete your presentation?
I'm sorry, it's like doing something weird.
Does that complete your presentation?
Yes, ma'am.
Okay, I just had one quick question, and that is if you had heard from any of those residents from the condos that are in the separation area.
No, ma'am, I have not heard from anybody. I also want to add that apparently back in 1983, this was what at one time for a 2 APS. If they are, please resend that.
Okay, all right, thank you so much, I appreciate it. We'll go to Development Services.
Thank you, ma'am.
Colleen Marshall, Development Services. The applicant stated the request is for a 2 COP alcoholic beverage permit with distance separation waivers for a proposed restaurant located at 730 West Brandon Boulevard on property zone commercial general. The applicant's requesting a distance separation waiver of 227 feet from the proposed structure to residentially zoned property to allow for a 23-foot distance separation. The proposed wet zone area and associated restaurant are separated from the residentially zoned property to the north by a masonry wall, drive aisle, and a landscape buffer area. In addition, all alcohol sale and consumption will occur inside the restaurant. The vehicular and pedestrian travel distance between the entrance of the restaurant and the residentially zoned property exceeds 250 feet. In addition, there is no direct pedestrian access from the residentially zoned property to the restaurant. A waiver is also sought to the number of similar alcoholic beverage permit classifications within 1,000 feet. There are currently 6 existing similar classification permits within 1,000 feet of the proposed wet zone area. Of the 6 approved similar alcoholic beverage permits within 1,000 feet, 4 permit locations are separated from the proposed wet zone area by roadways, State Road 60, an 8-lane principal arterial highway with approximately 170 feet of right-of-way width, and North Kings Avenue, a 2-lane collector roadway with approximately 60 feet of right-of-way width, and therefore have no functional relationships to each other. Of the 2 similar classification alcoholic beverage permits approved within the same northwest quadrant of the intersection of State Road 60 and North Kings Avenue, 1 permit is not currently operating or utilized. The 3 PS alcoholic beverage permit location at 700 Brandon Boulevard was approved under petition SUAB 03-0416, and the approval runs with the land. However, the business that utilized the permit is no longer located at this location, and the building within the wet zone footprint was demolished in 2017. when the site was redeveloped into a new gas station and convenience store. The new convenience store is located further north of the previous location and received a 2 APS alcoholic beverage permit under petition SUAB 170338. The location of the 3 PS wet zone area is now part of the parking spaces and drive aisle of the parking lot for the current convenience store, and is unlikely that the 3 PS alcoholic beverage permit location would be utilized in the future given the redevelopment of the site. State Road 60 in Brandon is the principal arterial highway, and the area along the highway functions as a large commercial corridor with numerous retail, commercial, and restaurant establishments, as well as numerous alcoholic beverage permits. As commercially zoned area is where establishments selling alcoholic beverages would be expected to be found. For these reasons, staff finds the proposed wet zoning does not pose new impacts on surrounding land uses, and the necessity for the specified distance requirements is negated. Staff finds the proposed special use alcoholic beverage permit to be approvable based on the wet zone survey, reflecting a total of 3,382 square feet, as shown on the wet zone survey received October 7th, 2024.
Okay, thank you so much. I appreciate it. Is there anyone in the room or online that would like to speak in support? Anyone in favor? Seeing no one, anyone? Sir, did you raise your hand? Yes. Oh, you'd like to speak in support? Come forward then. Support, yes. All right, you could give us your name and address, please.
Good morning, Robbie Fox, 11231 Great Neck Road, Riverview, Florida, 33578. I just would like to say thank you as the owner of Josephine's Italian Market, lifelong resident here in the county. This was a dream of mine over the past 30 years. I was in corporate America for 25 years and decided to exit early and open up an Italian market in Brandon. So I appreciate the support, and thank you.
Thank you for coming down. If you could please sign in with the clerk's office. Anyone else that would like to speak in favor of this application? All right, seeing no one, anyone in opposition? All right, Ms. Marshall, anything else?
Nothing further.
Okay, Ms. Liberty, you have the last word if you'd like it.
No, ma'am, there's nothing. Have a great day.
You too. Thank you so much. And with that, we'll close special use AB 25-0040 and adjourn the hearing. Thank you all for your time and testimony.